I'm grateful to my brother Ibrahim for this kind invitation. It's great to be back in Harvard Law School, which played such an important formative role, together with my brother James, who has gone on to become a very distinguished scholar. I will be very brief. As we say in the Middle East, we have 4,000 years of civilization, but we're half an hour late. But I will not be that late on this occasion. I was really pleased to hear the comments of the panel, and coming out of this historic hearing in September of last year at ITLOS, I think it was, for me personally, a historic, I would dare say, revolutionary moment for two reasons. One is that the smallest of nations on earth, Tuvalu population 11,000, Antigua population 90,000, comparatively large, but still the smallest of nations, which are the canary in the coal mine of climate catastrophe, having been, to put it mildly, frustrated, disappointed, brought to the brink of threatened extinction in the case of some, which will disappear because of rising sea levels, gave up in effect on the COP process, taking seriously the 1.5 degree target, and turned to international courts and tribunals, at the very least to try and change the conversation from one of unilateral, vague commitments, which at present are such that by the year 2100, we are projected to reach 2.8 degrees Celsius, which is twice the ceiling, which scientific evidence, uncontested scientific evidence, tells us is the point beyond which we will suffer irreversible catastrophic harm. So it was remarkable to see the prime ministers of Antigua and Barbuda and Tuvalu standing before ITLOS, speaking about the consequences of humankind's folly, and basically telling the 21 judges of the tribunal that if international law has nothing to say about this matter, which threatens the very survival of all humankind, then what good is international law? We hope in May of this year to receive the opinion, and the crucial question will be whether that opinion will go beyond abstract principles in order to enter into the scientific evidence, because the abstract principles are not difficult to discern. No one among the 50 states and international organizations that participated questioned that greenhouse gas emissions are a form of pollution under Article 114 of UNCLOS. So the question is not so much does Part 12 apply, because it clearly does, but what does Part 12 require in terms of specific obligations of states individually and jointly to keep temperature rise within 1.5 degrees Celsius. And it will be very interesting to see the sequencing of the ITLOS opinion with the proceedings in the ICJ. Just yesterday we received a notice from the registry that no fewer than 92 states and international organizations have submitted written statements, which I believe is unprecedented in the history of the court. So the question also will be whether a robust opinion by ITLOS will also shape the jurisprudence of the ICJ. I also want to turn back to some of the comments that were made in the previous panel, together with my dear colleague and brother Charles and others who were making excellent submissions in ITLOS, the Honorable Minister of Justice of Sierra Leone, whose words that you're taking the bread out of the mouth of our children, I think was one of the most vivid examples that this is not an academic exercise, that this is an unfolding catastrophe. We are already in the middle of it. But to turn back to the question of ownership of international law by the people of the Global South. And in that respect, although the Commission of Small Island States team had very distinguished scholars, academics, seasoned practitioners, I was very pleased that we had among our 17 counsel and experts, 9 men and 8 women, 9 from the Global South and 8 from the Global North, which should be a natural state of affairs, but is utterly revolutionary by the sad, very sad standards of the ICJ bar. But I want to just reflect on one counsel in particular, 24-year-old Naima Fifite Temaile, a recent graduate of the University of Hawaii, whose name Temaile is a small island in Tuvalu, after which her grandfather had named her, who is now the mother of a beautiful one-year-old child, who showed up in court not wearing the robes and wigs of the English bar or the sartorial splendor of the French academics with the red robe and the rabbit fur or what have you, but she walked into the courtroom with a crown made of seashells, and she spoke like a queen before the tribunal, and you could see the rapt attention of the judges as she explained how her one-year-old would never be able to see the island after which her grandfather had named her. Which brings us to the bigger question of beyond TWAIL and all of the theoretical approaches that we have, critiques of international law, whether emotion and culture and the manner of expression itself is an essential part of advocacy, which we need to rethink. How do you persuade a panel of judges beyond logical reasoning? So I will end there, but only to express great appreciation to be invited to this very important event. And I'm very, very encouraged to see my African brothers and sisters who are the next generation, if not the existing generation of leaders. And I'm sure we have yet to see very significant transformations of international law in the years ahead. Thank you.